Good. Well, thank you all for returning so promptly, and I'm glad that we're going to have the full time to talk on this panel because it really is an extremely interesting panel. The purpose of it, as we set it out, was to move from that very compelling keynote to have a panel in which two experts in the field would talk broadly about themes, first in the international arena, where religious freedom has become an issue that's increasingly discussed all over the world, and then to move to a discussion about the shape that those discussions have taken over the last 15 to 20 years in the United States, both the issues that have provoked discussions about religious freedom, the type of language that courts use to resolve them, and the state of the law that we're in. And this is going to be not only interesting on its own, I hope, for all of you, but really useful as a sort of background and a place setting for the panel, the next panel, the second panel that we have, in which we'll be talking about recent case law and legislative developments in the state of Washington, many of which are responding to national trends, and in some cases contributing to them in very interesting ways. So with that background, I'd like to introduce our two speakers. One has already been introduced. So Dr. Lantos Swett, as you know, has had an extremely distinguished career, not only as an academic, but as a semi-governmental, independently governmental official on the Commission on Religious Freedom, and of course as a very active member of civil society around the world and in the United States. And she is deeply vested in and familiar with the issues of religious freedom as they are discussed in the international arena, and she's going to focus on that. Our second speaker is Professor Brett Scharffs, who is the Francis Kirkham Professor of Law and just recently the Rex Chair, or the Rex E Chair at Brigham Young University, and he directs the International Center for Law and Religious Studies there. And he is both an expert in international and domestic trends in religious freedom, law, and litigation, but he's going to be focusing his talks primarily on national trends. Professor Scharffs, just to give you a bit more background, was a law clerk on the DC Circuit. After graduating from Yale Law School, going to Oxford as a Rhodes Scholar, and getting his BA and MA at Georgetown University. He clerked on the DC Circuit. He also clerked on the Iran Claims Tribunal, probably the most effective international tribunal that we've had, arguably. And then he practiced at the law firm of Sullivan and Cromwell, giving him legal practice. He has taught not only at BYU, but at Yale University and GWU. He has an enormously rich publication history and has worked on a casebook that is really pioneering in the field. It is Law and Religion, National, International, and Comparative Perspectives, which is published by Aspen, and I urge you all to take a look at that. He has done an enormous amount of service, both within the academy and into the international community, broadly speaking. He lectures and works on religious freedom all over the world, and we're very lucky to have him join Professor Lantos Swett here. With that background, if we could turn it over to Dr. Lantos Swett, and you could begin.
Great. Well, I apologize. You've already heard me enough, so I'll keep my remarks at this juncture relatively brief, because I think we really hope to have as much both dialogue amongst us, and then this is going to be an opportunity for questions, right, as well.
Absolutely.
So I don't want to take too much time. I hope I have made the case in my earlier remarks that that religious freedom is important. It's not peripheral, it's not inconsequential, and as it relates to our international relations and foreign policy, it is my view that it is not a mere desiderata. You know, this is sort of nice, it kind of represents American values. We'd like it if people around the world, you know, sort of had access to religious freedom, and we'd like it if other countries respected it. No, I think it's actually quite a bit more serious than that. And I have argued on many occasions and believe quite strongly that promoting respect internationally for freedom of religion, conscience, and belief is really kind of central to our own national security and well-being. If you sort of overlay the list of countries that, for example, USCIRF, the commission I served on, has identified as countries of particular concern, CPCs, the most egregious religious freedom abusers in the world, and overlay that list on the list of countries that, our National Security Council, the State Department, the Defense Department would list as the greatest threats to our country in terms of international terror. Those lists match up to a remarkable degree. And I would argue that, that it is, at least in part, the sort of hostile environment that many of these countries have to the fundamental notion of freedom of conscience and belief that drives a lot of the extremism and the tendency towards violence that really does pose real and concerning risk to our society. So I guess I would start out by saying that international religious freedom is not just kind of a nice, goal that, let's encourage people. It is in our national interest. Some of the issues, some of the sort of cross currents and leading issues in the field of international religious freedom, I want to touch on just briefly, and then happy to discuss them further as the conversation goes on. One has to do with the question of defamation of religions. This is a really, really big issue in the international religious freedom field. There are a number of countries in the world where blasphemy or defaming religion, apostasy, things which should be, private personal sins, perhaps with some sort of sanction within one's faith community, are actual crimes carrying the death penalty. And we have been fighting something of an ongoing battle over a period of many years in various international bodies against the effort by some countries to make the defamation of religions sort of something that the world community goes on record as opposing. And the United States has opposed that very forcefully. We have tried to make the point again and again that religious freedom is about protecting the rights of individuals to their personal conscience rights. It is not about protecting religions from criticism by their adherents, by non-adherents, by secular forces, by anybody. And that's a very fundamental difference of worldview. The goal is not to protect religions. The goal internationally should be to protect the individual's right, their conscience rights to the free exercise of their conscience and their religion. And so that has been sort of an ongoing push and pull. And I would say, and I'm very pleased to say, that for the most part, the broader conception has prevailed in the various international bodies that have considered this. One of the issues we see in a lot of countries, Russia would be a very good example of this, Egypt and other places, is governments using the pretext of fighting extremism as a cover for repressing the rights of religious communities that are disfavored. Most often, I would say it would be members of Muslim communities that are injured by this abusive use of anti-extremism laws. It is their communities that are targeted, their religious materials that are banned, but it's not exclusively Muslim faith communities that are the target of these overbroad anti-extremist laws. Recently, some of you may have followed in the news that Russia has been imprisoning members of the Jehovah's Witnesses, outlawing their translation of the Bible, their ability to distribute their brochures and their material, which is very central to the practice of their faith life, because they have ruled that those materials constitute extremist literature. And so this is another kind of government-sponsored threat that we see to freedom of religion, which is widespread, and sometimes we find it in surprising places. And, I think it's something that even in the United States we have to be aware of, alert to. In general, the United States ranks very, very high in the global scheme of things in terms of the robust protection for freedom of religion that we have in this country. But some of these are slippery slopes, and we need to be at least aware of the threat. Was it Benjamin Franklin who said, he would give up his freedom in exchange for security, deserves neither. And it's sort of a broad statement that I think has some relevance here. Another threat that we see in parts of the world to religious freedom comes from exactly the other direction. And that is in some of the most secularized communities in Europe, where there is a legal and a social hostility to the expression and the manifestation of people's religion in their public interactions. So, France has been notable in this regard. France has a really interesting history. They have enshrined sort of in the French Republic, going back now well over 200 years, this idea of what they call laïcité, which is an aggressive, not just separation of church and state, but sort of exclusion of, all elements of religion from the public square. And we have seen that take a rather aggressive form in France, again, tending to target the Muslim community there. So burqa bans. In France, there have been various legislative efforts to ban the wearing of explicitly religious symbols in public institutions, courthouses, at schools, stuff like that, which is a real impediment to devout Muslims, to devout Jews who wish to wear the kippah, and to some devout Christians. So, it's important, I think, as we look at the range of threats to religious freedom internationally, that we realize it's not all of a piece. It's not just, oh my goodness, conservative Muslim countries are repressing the religious freedom of other communities. It's not just, North Korea and China, these atheistic communist countries, and believe me, those are both incredibly dreadful places on religious freedom grounds, but it is more complicated, it's more varied, it's more nuanced than I think we often recognize. And I want to perhaps close by just bringing up one more very tragic situation, which is very top of mind. But again, I think it's important that we talk about it, because sometimes we have a simplistic narrative around the threats to religious freedom and, who out there in the world, what religious groups are dangerous and what religious groups are peaceful. And I'm thinking now of the plight of the Rohingya Muslims in Burma. Now, most people, again, and I'm just being really candid, kind of rubber meets the road here. If you say, okay, let's talk about different faith communities, they say, Buddhists, peaceful, lovely, gentle people. Muslims, maybe a little extreme, maybe a little dangerous. Well, my friends, we need to look at the situation in Burma, where we see a small, terribly persecuted Muslim community, the Rohingyas, being horribly attacked and driven out of their country, really being ethnically cleansed by a nationalist Buddhist government, and majority. It's one of the gravest human rights and religious freedom outrages unfolding right now as we sit here today in the world today. And so I bring it up not only because it is a crisis that merits your concern and your attention, but it is also a crisis that, to me, is an important reminder that we are going down a dangerous path when we think we can generalize, when we find ourselves tempted to categorize and to make assumptions about different faith communities and their adherents. And so why don't I maybe stop there and look forward to more conversation about this as we go forward.
Great, thank you very much. Brett, you want to go?
All right, so I've been asked to talk about the United States, and I'm going to do that. But just picking up on this last observation that Dr. Swett made, I think what's happening in Myanmar is, in a way, part of large trends that we see happening around the world. And I just want to talk for a minute about religious nationalism and the challenges that accompany religious nationalism. What I mean by that is the tendency to do two things. One is to identify what it means to be a good citizen of a country with belonging to a majority religious group. And then the second is the close political alignment between that majority religious group and the people who wield political power. And so when we think about this problem of religious nationalism, we're very familiar with it and its increase in the Muslim world. We see it with Sunni alignment with secular power, government power in Saudi Arabia, and with Shia alignment with power in Iran. But we also see it in really alarming and troubling ways in countries that have been held out as models of the possibility of a moderate Islam. I'm thinking here primarily of Turkey, but also the back and forth of what we've been seeing going on in Egypt, which are really two enormously important and large Muslim countries. I think we even see it happening in Indonesia, which is the largest Muslim country in the world by population. The recent use of the anti-blasphemy laws to target the candidate for governor of Jakarta for basically saying, you can be a good Muslim and vote for me even though I'm a Christian. He was then convicted, and his conviction was upheld by the Supreme Court, and he's now in prison for blaspheming Islam. And so we see this very strong push to say that to be a good Indonesian, you must be Muslim and you must vote only for a Muslim. And I think what we're seeing in Myanmar is another face of that, although it's Buddhist nationalism there. I mean, Myanmar is a place that's been under terrible military domination, and among the groups that were persecuted were Buddhists. But now there is this strange sort of political alliance between the Buddhist majority and the military that still wields veto authority over what happens in Myanmar. But there's this strong sense that to be a good Burmese, it's to be Buddhist. And Burmese, after all, it's the biggest ethnic group in Myanmar. There's more than 50 ethnic groups in Myanmar, so it's a very complex and diverse place. But the Rohingya are viewed as illegal immigrants. They're viewed as people who are there and not real citizens. And so this is viewed as a citizenship problem. But the reason it's viewed as a citizenship problem is because there's this deep religious nationalism which says to be Burmese, you need to be Buddhist. And that's what it means to be a Myanmar citizen. We see something very similar in India with Hindu nationalism. I have good friends who are Muslim in India, and for many years they've been fierce defenders of the Indian approach to religion in the state. There's much more of a sort of a cooperation between religion and the state than we'd be familiar with in the United States. And so, for example, the government has been willing to fund Muslims' journeys to the Hajj, to return, to go to Mecca. And it's interesting because over the last few years, there's been a real shift. And about 2 years ago, I was asking this friend who used to be on the Minority Law Commission. I mean, this was like an insider, really elite type of Indian. How are things going? How are you feeling? And he said, I feel nervous. And he felt nervous because of the rising nationalism of Hindus in India. And when I saw him most recently, a few months ago, I asked him, how are things today in India? And what he said upset me. He said, I feel scared. And that was a step further of what he was feeling with this sense of religious nationalism. And I think what we're seeing in Russia is also very similar, although there's the Orthodox Christians, of course, but there's this strong alliance between Putin and the Orthodox patriarchs. And there's this sense that to be a good Russian, you must be Orthodox. And if you are a Jehovah's Witness, if you are a Scientologist. Muslims are a little different because they've been there historically for so long. It's not an immigration issue like what you're dealing with in Europe. It's sort of Muslims who have been there for hundreds or thousands of years. And so it's a little bit more of an indigenous peoples type issue that Russia is dealing with. So Muslims don't face quite the same pressure that minority faiths, especially those that are affiliated with foreign, that are viewed as foreign faiths. But it's this very strong sense that to be a good Russian is to be Orthodox. And one of the things that, as a friend of religion, has troubled me the most is that if you look at the data of where there are the highest restrictions on religious freedom around the world, both legal restrictions and social hostilities with respect to religion, it maps almost perfectly to those countries where the dominant religious group is more than 70% of the population. And in a way, it doesn't matter if that 70% is Muslim or Hindu or Orthodox Christian or Buddhist, you still have very high restrictions on religious freedom. And so if you were forced to identify the most powerful threat to religious freedom in the world, I think you'd have to answer religion is the greatest threat to religious freedom in the world. And there's an exception to that, and that is Catholic supermajority countries. There are about 30 countries in the world that have 70% or more Catholics. And none of those countries have high or very high legal restrictions on religious freedom. And only 2 of them have high social hostilities. None of them have very high social hostilities. Those 2 are Italy and Mexico. So what this suggests is that perhaps it is the religion, the majority religion, that determines what the attitude towards religious freedom is. And in the Catholic Church, you have Dignitatis Humanae, which just celebrated its 50th anniversary. This is the Vatican II document that articulated in a very clear and forceful way that religious freedom is a fundamental truth and doctrine of the Catholic Church. Now, if you had asked the question 150 years ago, what's the most powerful institution on earth opposed to religious freedom? You might have answered the Catholic Church. But if you ask the same question today, or the opposite question, what's the most powerful institution on earth today that defends the principle of religious freedom? I think you'd answer the Catholic Church. I'm not even sure who would be second. Maybe Katrina's office at the U.S. Commission, but it would be a distant second. It's sort of 20 people in a dilapidated World War or Civil War era office building that is basically using a bully pulpit as best they can. But the point is that it's really going to be for religious people working within their own traditions that the solutions for religious freedom are going to be found. And so Muslims ultimately will be convinced that religious freedom is important, partly from the experience of Muslims who live as a minority. So here I'm thinking of American Muslims. After all, it was American Catholics, John Courtney Murray in large measure, who was instrumental in nudging the Catholic Church towards accepting religious freedom as an important doctrinal value within the Catholic Church. It's going to be a little harder for Islam because it's structured much more like Protestant Christians than Catholic Christians. And so you don't have the Pope who you can go and have sign a declaration which changes everything forever. But nevertheless, it will be from within those traditions. And what's troubling about the religious nationalism is we even see it in Catholic countries. Here I'm thinking about Poland and Hungary. Recently, there are very powerful political movements in both Poland and Hungary that are arguing that to be a good, true, real Pole, you must be Catholic. And we see something similar in Hungary. There it's the emphasis is on nationalism rather than religious, whereas in Poland I think it would be vice versa. But even in those Catholic majority, supermajority countries, there is a temptation towards religious nationalism that is very threatening to religious freedom. So let me shift gears from the international setting to the U.S. And we talk in very dire ways about religious freedom in the United States. If you listen to conservative talk radio, you'll hear a lot about the war on Christmas and whether department stores are saying happy holidays or Merry Christmas and so forth. And it's easy to imagine that these are important, but it makes you grateful for your own plight when you think that in many places in the world today, there are people who are persecuted or even subject to genocidal pressures or becoming refugees, displaced persons because of their religious affiliation and their religious identities. And I think that we treat religion and religious freedom in quite a trivial way in the United States when you think about how important this is as a fundamental human right. For example, in the United States, we frame the debate almost exclusively as a conflict between non-discrimination and religious freedom. And the non-discrimination norms are primarily sexual freedom norms and most predominantly gay rights. And so we have this sort of battle between non-discrimination on the one hand and religious freedom on the other hand. Well, this is bizarre because if you look in the world of who is suffering discrimination and who is dying because of discrimination, it's largely religious minorities. It's religious people. And so we have the luxury of creating this fight between non-discrimination on the one hand and religious freedom on the other hand, ignoring that one of the most, not the only important, but one of the most salient forms of discrimination that creates suffering and hardship in the world is religious discrimination. And so I think we can easily imagine that our way of viewing these is the way things are, but we sort of have a luxury problem, which is sort of what to do about the Colorado baker rather than sort of existential problems, which are what people of faith are facing in many parts of the world. So in the United States, I think religious freedom is quite well protected. I have a colleague who looked at the voting records of every justice on the Supreme Court and over the last 20 years, and their voting records on cases involving religious freedom. And they're all pretty good. Religious freedom often wins in the Supreme Court. There is a but, and that but is there are some justices that when the conflict is between religious freedom and reproductive rights wins. And so if there's a case involving religious freedom versus reproductive rights, I'd wager money on how Ruth Bader Ginsburg is going to come out in that case, and it won't be on the side of religious freedom. The other is gay rights. When the conflict is between religious freedom and gay rights, then it's much more evenly divided on the court as well. And the key justice becomes Justice Kennedy. And of course, we resolve all important issues in the United States on the basis of one man, one vote. and that man is Justice Kennedy. And it's not a great way to run a democracy, but that's how we've decided to decide gay marriage in the United States, which I think is unfortunate for gay marriage as an institution that's socially accepted, because I think that much as what happened with abortion with Roe v. Wade, cutting off a debate and a movement which is moving generally in the direction towards liberalization has the effect of emboldening and entrenching the opposition in a way that's I don't think has turned out to be healthy for abortion rights in the United States. And it'll be interesting to see if there's a similar sort of trajectory with respect to gay rights in the United States. But to my mind, the biggest challenge facing religious freedom in the United States today is the politicization of religious freedom. It wasn't that long ago when the Religious Freedom Restoration Act was passed virtually unanimously by both houses of Congress, and President Clinton signed it with great fanfare. And then when it was struck down, we had state RFRAs which were quickly passed in many, many states. But that has changed in the last 5 years, and especially in the 3 years since Obergefell, where today, if you ask Democrats and Republicans their attitudes about religious freedom, it's politicized in the way that so many things are politicized in the United States today. There is a majority of Democrats, a significant majority of Democrats, who think of religious freedom as a pretext for discrimination against sexual minorities. And there's a supermajority of Republicans who believe religious freedom is an important constitutional value. And whatever whether you're an accommodationist or a separationist on Establishment Clause issues, I don't think it's healthy and a good sign that religion and religious freedom has become politicized to the extent that it has. And I was thinking about this yesterday as I was flying here, and I've changed my approach to what I wanted to talk about, because I wanted to just talk about how this gets presented in our popular culture. And so this is an article that was published in the New Yorker on October 11th. So it's not in the current issue on the newsstand, but it's available online. It's by Masha Gessen, who is a staff writer at the New Yorker, and I think is someone who had to flee Russia because of persecution, because he is gay and, she.
I met her.
Oh, you know her, okay. So she had a child, and there was a threat that the state was going to sort of take the child from her. So this is someone with a real lived experience of persecution on the basis of her sexual orientation. Here's the headline: How Trump Uses Religious Liberty, and of course it's in scare quotes, to attack LGBT rights. Now, I'm not here to defend President Trump, but what I want to focus on is sort of the way this debate gets presented, the debate between gay rights and religious freedom. The first thing to note is the scare quotes. Religious liberty is really highlighted as something which is delegitimized through the use of these, that is viewed as pretextual. Imagine a headline that says, "How Obama Uses Gay Rights to Attack Religious Freedom," and gay rights were in quotes. Would you trust that source of information? It would be difficult to trust that source of information, because anyone who's going to put gay rights in scare quotes, you realize, is propounding a position, not just trying to engage in analysis. And this article wasn't an opinion. This came from the news desk. That's how it's characterized in the New Yorker. The second thing the article does is it's filled with language saying that, President Trump is promoting measures that explicitly legalize discrimination if motivated by religious belief. And this is a very common line that we think about when there are tensions that arise between religious freedom, religious conscience on the one hand, and non-discrimination norms on the other. We're legalizing discrimination. And we live in a political moment when being accused of discrimination is one of the worst things that can happen. The non-discrimination norms are much more salient politically than the freedom norms. I mean, think of same-sex marriage. It was freedom to marry for a long time, and that slogan didn't get us gay marriage. What got us gay marriage was marriage equality. And to me, that's interesting because those equality norms are very resonant in our culture. And so to be accused of discriminating when you are exercising religious conscience is a powerful form of delegitimization as well. None of us want to be accused of discriminating. But it's actually more nuanced than the bumper sticker or the accusation makes it sound. For example, there was an interesting case in San Francisco, of all places, a few years back involving housing discrimination. Now, none of us want to be discriminating in housing, and this had to do with an advert. This was back when people still put advertisements in the back of newspapers, and there was an
newspaper?
There was an advertisement for a roommate, and it was looking for someone who was a single white female, SWF, right? Now think about it. You've just discriminated on 3 impermissible grounds. First of all, if you're looking for someone who's single, you're discriminating on the basis of marital status. That's not good. White, you're discriminating on the basis of race, and female, you're discriminating on the basis of sex. And so with a 3-letter acronym, you've engaged in 3 forms of invidious discrimination. And so the case was brought saying that this was a violation of the non-discrimination law that was very strongly articulated in the San Francisco City Ordinance. Well, it went to the court, and the court said, that's not what the non-discrimination statute means. Because after all, in our most intimate associations, in our home, we need to be able to feel comfortable with whom we're sharing our home. And so basically, discrimination won. The right to discriminate was vindicated. But what this story illustrates is that framing it as a matter of discrimination sometimes doesn't capture the nuance of the issue. And so, for example, when the Pope abdicates and the College of Cardinals meet, and they consider only Catholics for the job of Pope, it would be kind of weird to accuse them of discriminating on the basis of religion, although clearly they are. And there are a lot of things that are like this. I mean, there are small hair salons that serve people with certain types of hair, with certain ethnicities and issues. There are, women who want to go to gyms where they're not being oogled by men. There are a variety of ways in which we can make space for each other to operate in a pluralistic society where we don't need to invoke the concept of discrimination so quickly. The problem I had with reading this New Yorker article is this concept of discrimination is just invoked and wielded as a hammer to just beat the people with whom you disagree. But when someone is acting out of conscience, they're typically not trying to discriminate. They're typically trying to live true to their deep views of who they are and their place in the universe. And it seems to me that we ought to be able to carve out enough space for conscience. The metaphor I like is constitutional space. We want to live in a society where we have a little bit of elbow room, where we can live with each other, and sometimes we might be offended. There was the blasphemy example that was given. And so I'm Mormon. The Book of Mormon is a musical. It ridicules religion. It ridicules my religion. Great punchline is shoving a Book of Mormon up someone's rectum. Great line for a laugh, but that's offensive. It's hard to imagine that being done with the Quran and being accepted within our society. But that's part of living in a plural society. Part of living in a plural society with free speech protections is realizing that what you hold sacred might be ridiculed by others. And that's just sort of part of the price of living in a plural society. And part of the elbow room you give is to allow others to ridicule what is sacred to you. You don't have to like it. You don't have to choose to do that yourself. You don't have to fund it. You don't have to go to that play. But we tolerate it. And that's part of what it means to live in a plural society. So I think this language of discrimination gets overused. Think of a family business. Small family business. The father hires his son. He's probably discriminated on the basis of race, gender, religion, nationality, geographic location. But we don't want to forbid the owner of a small business from being able to hire their son. And so even in Title VII, which prohibits discrimination on the basis of race, small businesses were excluded. Initially, it was businesses of 25 or fewer. Later, the number was reduced to 15. But basically, the idea is, if you're running a small business and it's a family business, you're going to discriminate on the basis of ethnicity or religion. And that is not something that we want to treat as a five-alarm fire and as an issue in our society. Or housing discrimination. We have carve-outs for units of 4 or fewer. Most of the housing laws I'm familiar with have exceptions. You don't discriminate on the basis of sex. You don't discriminate on the basis of marital status. You don't discriminate on the basis of race. But if you're in a duplex, there's an exception. It's not because we want people in duplexes to discriminate. It's partly because they're bigger fish to fry, and it's partly because we just want there to be some elbow room, constitutional space for people to choose who they feel comfortable living in most close proximity with. And we choose to place that outside the discourse of discrimination. And so I think we want to be careful about this discourse of discrimination and the accusations of discrimination that come so quickly from our lips. The next thing this article does is it calls everything a religious freedom law. It says that all of these things that President Trump is doing is favoring religious freedom laws and opposing gay rights. And the list includes his reversal of the Obama administration's transgender bathroom in schools regulation. Well, that's not a religious freedom law. That doesn't have anything to do with religious freedom. There may be religious conservatives on one side of the issue and non-religious people on the other side of the issue, but that's not a matter of exemptions for religious conscience. But nevertheless, it's put into the laundry list of this conflict between gay rights and religious freedom. The next thing is the ban on transgender service members. That's not a religious freedom issue. That's an issue about, national security. It's about the Army's policy, the military's policy of readiness and fitness of troops. But it's not it's not a conflict between a religious freedom statute and gay rights. Nevertheless, it's characterized as a conflict between those things for rhetorical and political reasons. What about the Colorado Baker case? The Masterpiece Cake Shop case. This is also listed as a a case that's a conflict between religious freedom laws and gay rights. It's not. The Colorado Baker case is a non-discrimination statute. It's a state non-discrimination statute that says you can't discriminate on the basis of sexual orientation. And the Baker is making a freedom of association and a constitutional free exercise claim. But that's not a conflict between a religious freedom law and gay rights, and nevertheless is put on that list. The next thing was the transgender employees in federal employment. That's not a conflict between a religious freedom law and gay rights. It's about the interpretation of Title VII. In order to sink Title VII, which was to prohibit discrimination on the basis of race, a bunch of senators decided to add sex because they thought, look, that's going to explode this. No one would vote for something that says you can't discriminate on the basis of sex. And so they put in sex as a prohibited basis for discrimination as a method of killing the bill. Well, much to their surprise, the bill passed. And so you get Title VII prohibiting discrimination on the basis of race and sex, as well as religion and a few other things. But the Obama administration interpreted the prohibition on discrimination on the basis of sex to include you can't discriminate against transgender. No one was thinking about transgender when Title VII was enacted. It may or may not be a legitimate interpretation of the prohibition on sex discrimination, but it's not a fight between religious freedom on the one hand and gay rights on the other hand. And so what we have is we live in this political moment where there is this impulse to frame everything as a conflict between religious freedom on the one hand and gay rights on the other hand. Finally, the emotive language, which is very strong. In this article, the author talks about anti-queer gestures, anti-LGBT rights battles, homophobic campaigns. She says that protecting the children is the battle cry of xenophobes of all stripes. She says that this is based upon imaginary threats of pedophilia and homosexual recruitment. I'm not sure it was imaginary when we were worried about Catholic priests. It's ominous that the relitigation of LGBT rights will center on children. So my point is that it's really easy to invoke highly emotive language when we're engaged in these difficult and sensitive issues. And the issue of knowing where to draw the line between accommodating conscience on the one hand and enforcing norms of non-discrimination on the other hand are important and difficult questions. But we've learned how to deal with them in a variety of areas. We've decided that we're not going to force Catholic bishops to marry Jewish couples, although that's discrimination on the basis of religion. We've decided that we're going to give some space to employers in very small businesses and to people with housing in very intimate settings. That doesn't mean that we've given up on the norms of believing that non-discrimination is an important value, that non-discrimination on the basis of race is important, and sex and sexual orientation is important. So let me just conclude with just a few more thoughts about the Masterpiece Cake Shop case, because this is the big case that's before the Supreme Court right now that has a very strong companion here from Washington, the Arlene Flowers case, which the next panel will be talking about. As I said, this is a state anti-discrimination statute that prohibits discrimination on the basis of sexual orientation when you're running a business, what's sometimes called a public accommodation statute. And what we have is a religious conscientious objector. We have a sincere person who's happy to serve gay customers and to make cakes for gay customers, but doesn't want to be compelled to participate in a gay wedding. And his argument is that this is expressive conduct and that he is a cake artist. If you read the brief, it's interesting because the rhetorical strategy of the people defending the baker is to really emphasize this idea of artistry and so forth. This is really important. And so in a way, you have this idea of expressive conduct, making a cake to celebrate a wedding, and one side is emphasizing the expressive element, the baker, and the other, the conduct element. If you look at the brief of the same-sex couple that was denied, their brief basically says, this is not about art, this is about discrimination. A cake is just a cake, right? And so there's this idea that this is really about conduct. This is about discriminating against people because they're gay. Well, there is an irony in this case, and that is, on the one hand, the gay couple is arguing that this is just a cake, and the cake is not expressing a message, it's just delivering a good. And yet, on the other hand, the decision not to bake the cake is really harmful and hurtful. It's hard to understand how the cake can be at once unimportant and yet, on the other hand, so important. This came up in Utah recently because the LDS Church filed an amicus brief on behalf of the baker in the Masterpiece Cake Shop. And there was a big protest that broke out, and it was the gayest bake sale ever. And so there was a bake sale that took place right in front of sort of Temple Square, and the idea was to ridicule and to criticize the church for the position they had taken in the Masterpiece Cake Shop. It was a protest. It was a form of protest. And what was the form of protest? It took the form of cupcakes, right? These cupcakes, these little innocuous objects, were a way of sending a message that the Mormon Church is siding with bigots, people who would discriminate against gay people. And what's interesting is that in a way, this undermines the position of the petitioners in the case, because their argument is a cake is just a cake, but here we have the cupcakes being used as a way of sending a very powerful message of protest. And so I'm not sure that a cake can be both meaningless and meaningful. It ought to be one or the other. But maybe I'll stop there so we can have time for discussion. Thanks.
Okay, well, thank you, Dr. Scharffs. I realize I forgot to introduce myself. I'm Clark Lombardi. I teach here at the University of Washington. I have a doctorate in Islamic studies as well as my law degree. So I teach, and I have a joint appointment in the School of International Studies. So I teach Islamic law and law in the Muslim world, as well as comparative constitutional law and constitutional law here. So for me, this panel is particularly interesting. I've always tried to look at and understand constitutional debates in the United States, of which there are an increasing number in the area of religious freedom, and to understand them against a broader international backdrop, and hopefully to use the skills of studying another religious culture to be able to take a little critical distance on my own. So one of the things that I've found very interesting over the last couple of years, and it fits into what the panelists have talked about, is for me to try and understand how broader themes of non-discrimination, themes of religious nationalism are translated into legal language in the U.S. context. What we have seen over the last 15 years is a growing number of of statutes being written, lawsuits, and commentary, all of which is employing a particular language that you all have learned as lawyers, and that you are to the great happiness of the bar, continuing to learn about at CLEs at the University of Washington. But to try and take these broader issues that are of concern all over the world and to talk about them in a way that makes sense in the light of the United States' historical experience with religious freedom, and makes sense to lawyers who have been trained and judges who have been trained to think in a particular way. So with that, I just hope as a framing device for the way we get some questions, we've had some discussions about international themes, and I think they're extremely important, but I think some of you also will naturally raise some questions about whether religious nationalism is really an issue that is of primary concern in the Muslim world, and in particular countries like Myanmar. As someone, my mother was German, and I've spent a great deal of my childhood in Germany, and one thing that has changed enormously in Europe is the Christianization of political discourse. As part of the European Union, as it begins to wonder what it means to be European, what is the national identity that holds this very discordant group of countries together, people have sort of cast around. We won't all get a common government, so what is supposed to hold the European Union together? And there are populist movements in Europe, and it's not only in Hungary and Eastern Europe, but it is in Western Europe very palpably, in which people have decided that the European identity should be associated with, and they call it a Judeo-Christian heritage, but it is very much a Christian heritage. And the European Court of Human Rights, in a recent case, has held that it's perfectly fine for the Italian government to hang crucifixes in public schools when it's even notwithstanding the protests of atheists, because Italy's history is so wrapped up with Christian identity that it's part of Italian heritage to revere and identify yourself with a crucifix. This is not something that everyone is comfortable with in Italy, but this is the direction things have been going. And the Catholic Church, for all its great respect for religious freedom, has actually been very active through the Committee for the Defense of the Faith in arguing that this is actually a very good thing. The Muslim world gets Islam, and Europe should identify itself as Christian. So this is something that occurs in Western Europe, and arguably it's occurring, at least in some contexts, in the United States as well. And so we're going to hear about legal cases that have shown up in Washington State, in which the argument is going to be made, and it's going to be in tension with the argument that Professor Scharffs, you have made, and there certainly is a way in which the discourse in the New Yorker article may be unproductive in getting to the legal issues that are involved. But there are questions about whether the travel ban, which purports to be about national security, and the argument that the government would make about the travel ban would sound very similar to the one you're making about non-discrimination suits. This is not about national identity. This is not about religious nationalism in the United States. This is about national security. But there are arguments on the other side, and some courts have said, if you look at the way the travel ban was structured, and this is an argument made by the state of Washington, then we're not so sure that this is not, in fact, implicitly about religious nationalism. And the way the travel ban was structured, because it explicitly, at least in its first instance, did favor Christian refugees rather than non-Christian refugees, and because it was discussed by someone who had clearly espoused religious nationalist rhetoric in other contexts, even though not here, these all became part of the mix. And so these are going to be part of the debates that we're going to have to require everyone to make their own decisions, lawyers to make good arguments on both sides, and judges to make the best possible decisions they can in contexts like this. But what we're seeing here in the United States are the transmutations or the translations of these broader concerns that are existing all over the world. What does it mean to have an identity? Can you really separate out religious and ethical history of a majority people from the identity of a nation state? That's not an easy question to answer, and these are going to hover around it in a lot of contexts. And so, with that background, I want to ask take sort of moderator's prerogative to ask one question to both of the panelists, and then we'll open it up. And this is my question to you all. Since we've talked so much about religious freedom, and Dr. Lantos, Swett, you serve on one of the most important in the U.S. Institutions that try to identify violations of it. What is religion? And I ask that only because in the German context, of course, Scientology is not recognized as a religion, whereas in the United States it is. This isn't to take a position on that question. It's only to say that the question of what is religion is very different in different countries. In the United States' answer, we can talk about descriptively. It has answers that are quite confused, but normatively, we may wonder. And then to what extent, if Scientology is a religion, then to what extent is a sort of United States civic religion a religion that can impose on people who dissent from the fundamental values of America's civic religion, which I think may be the question that Professor Scharffs was implicitly getting at in some ways. Okay, so with that.
Oh, gosh, that's such a good question. Your question reminds me of why I like the broader formulation of freedom of religion, conscience, and belief, because I think it gives us a little more ability to encompass the convictions, the sincere conscience convictions of people whose convictions don't neatly fit into a definition of what is religion. You should have told me you were going to ask that question, because I would have thought about it more deeply. So instead, I'm going to default. I'm going to default to the line from a Supreme Court justice in the context of obscenity, where he said, I can't define it, but I know it when I see it. I think we all have an instinctive ability to know when something is a sincere manifestation of something we would call religion. Hungary a few years ago passed a rightly criticized, rather narrow religion law, which they then modified a little bit and expanded. But they were kind of trying to categorize what qualifies as a legitimate religion and what doesn't. And I remember, as I was talking with members of the Hungarian government opposing this effort that they were engaged in, they said, look, we have this woman here in Hungary who has launched the Church of the Pink Poodle, and she thinks she's entitled to various government subsidies to support this Church of the Pink Poodle. And, we all chuckled, and, I can tell you that the Church of the Pink Poodle, in my view, is not a legitimate religion, okay? So it's easier sometimes to say what isn't than what is. But I guess I would say two things. I would say that that's why I think it's so important to keep the focus on the protection of religious freedom and freedom of conscience and freedom of belief on the rights of the individual as opposed to the rights of any institution. That's why I think it's very important that we not move towards efforts to protect religions or faith communities from, defamation. It's the individual right that we are talking about, and that's actually central to the whole human rights project. Is this notion that human rights are individual? You don't get them by virtue of being a member of a group or an ethnic identity, but because of your just inherent rights simply by virtue of being a human being. So I don't know if that's an answer. If I'd had a little more advance notice, I would have done some deep thinking and some deep reading. But I think I'm instinctively know when something is a legitimate religion and when something isn't. But I don't know that that's a standard you could go forward with.
Dr. Scharffs?
It's a good question and an interesting question, but from a human rights perspective, an unimportant question. Because from a human rights perspective, what all of the human rights documents protect is a very broad category of thought, conscience, religion, and belief. And the official UN bodies that have sort of commented on what this means have made clear that this means theistic, non-theistic, atheistic, and other beliefs, including the right not to believe. And so, from a human rights perspective, religious belief is on the same footing as non-religious belief. Both are important and to be protected as inalienable rights. In other words, rights that we have prior to government granting them to us. And for defenders of religious freedom, this point needs to be made frequently and vocally, because non-religious people are often suspicious of religious people's claims of the right of religious freedom. And so different formulations are used. In Europe, the Norwegians came up with an acronym FORB, Freedom of Religion or Belief, and they talk a lot about FORB. I actually really prefer Dr. Swett's formulation. When she speaks about freedom of religion, what I've noticed is she always uses the same phrase. She talks about the freedom of religion, conscience, and belief. Is that right? And I think that's inclusive, and that's what deserves protection as a matter of conscience. Now, there are other important questions, like who gets a tax exemption? That's a different question than whether you have a human right to thought, conscience, and belief. For the question of who gets a tax exemption, different countries are going to have different formulations. The way it works in the United States is the IRS has a list of 14 common features of religion. And what they say is this is a non-exhaustive and not a non-exclusive list. These are not necessary conditions and not sufficient conditions. They are features of what a religion looks like. And so there are things like having a set of doctrines, having scriptures, believing in a higher power, congregating and meeting together. And basically what the IRS does is when a church is asserting a right to tax-exempt status, they look at their list, and then the closest I describe it to my students as a Wittgensteinian family resemblance test. It's sort of like figuring out what is a chair and what is not a chair. It's not that you have an essentialist definition. It's not that you have a functionalist definition. Those are the two competing definitions of religion that we see in the United States. But it's sort of a family resemblance type definition. So what I say is we're going to have different definitions for different purposes. When we're figuring out which religions in Germany get to participate in the state tax funding of religion scheme, there's going to be a different way of defining what is and is not a religion than if it's the U.S. IRS determining who's eligible for tax-exempt status. When sociologists talk about it, they're going to do it differently than when theologians do it. And when theologians do it, it's going to be a little different if it's a group of Christian theologians versus a group of sort of ecumenical, a broader group. My own view is that what we ought to do is start with something like a Wittgensteinian family resemblance test that gives a priority to self-conception. And so an interesting question is communism a religion? And we can debate that, and sociologists have debated it, anthropologists have debated it, theologians have debated it. And on some definitions, it clearly is. But what I think is, what did Marx say, the primary theorist? And he would be loath to say that this is a religion because it's sort of he defines it in part in contradistinction to religion. So I'd be quite deferential to Marx, and I would say, even though this has a lot of features of religion, because Marxists don't consider it a religion, we ought not also. Confucianism is kind of an interesting case because some Confucian philosophers would categorize it as a religion and others would not. So the self-conception is not quite as clear. So what I'd probably focus on is, well, what's the purpose for which we're asking this question? If it is to deny benefits, then I'd be skeptical of exclusivist definitions. If it is Confucius themselves saying, well, we don't believe in a higher power, we don't believe in this, we don't believe in that, this is an ethical system, then I'd be quite deferential to their saying, well, for the purposes of this discussion here and now,
we're not going to treat you as a religion. Now, if they're applying for tax-exempt status in the United States, they might be making a different argument, because there it might make sense. Here I'm thinking of Falun Gong, right? And Falun Gong in the United States argues that it is a religion. This is in part for political reasons. And when they're in China, they argue they're not a religion, also partly for political reasons. So sometimes it can be quite complicated. Scientology is interesting because it started out not as a religion, quite clearly in the mind of its founder, but it morphed into something that was quite clearly viewed as a religion by followers and adherents. And so again, I would be quite deferential to the self-conception of adherents. And if you ask a Scientologist today, is Scientology a religion? I think all the ones I've talked to and read about are going to answer adamantly in the affirmative, that it is a religion. And so my own instinct would be to be quite deferential to that. Now, the question about tax exemption is interesting with the Scientologists has gone through different stages in different countries, including the United States. There was a time when Scientology was not viewed as a religion, largely because their way of funding looked like sale for services. You pay a certain amount to audit to receive certain types of training. And this looks like a quid pro quo, an exchange transaction. And that looks a little different than a free will offering that we associate with religious donations. But then you stop and think about it, and you think about, well, what about the pew tax? Sometimes it's called that, right? Or the pew fee. Or what about the rabbi who charges a certain amount for performing a wedding? There are aspects of many very familiar religious traditions that look quite exchange-oriented. Or if you think about paying tithing and its relevance to salvation, for example, in the Mormon tradition, you could think of this as a quid pro quo if you thought about it in a very distorted and oversimplified way as well. And so I'm not sure that eventually the Scientologists got tax-exempt status in the United States, notwithstanding that their theology and their practice of generating income looks quite transactional in character. And to my mind, that's the right decision. It seems to me that for the most part, we're better off being generous and deferential to people's self-understanding. We do have to be a little bit aware of abuses. You have the prisoners who create the church of roast beef and fine wine, and that becomes their sacrament for Friday. And sometimes you just have to say no. But it seems to me that that is not usually the case. I had an interesting experience earlier this year. I was in the Netherlands. I was asked this very question, and in the room, I didn't recognize it at the time, but there was a Pastafarian. This started out as a joke, but it has kind of morphed a little bit like Scientology into a serious group of people who want to be recognized and respected as a religion. And one of the things they do is they wear a colander, is that what it's called, what you drain spaghetti in? On their heads. And she was there at my lecture with the colander on her head. And luckily I answered the question in a way that was sort of liberal-minded and inclusive, and she was really happy. She came up to me afterwards and told me about the travails she's been having in the Dutch legal system, getting the Pastafarians recognized as a legitimate religion. That, it seems to me, is a little bit on the borderline because it clearly started as a protest and as a joke, but it sort of morphed into something that was kind of a serious effort to, A, make a point, but B, also to create a ethic and a system of belief that's systematic in a way. So I don't know, maybe I'm soft-headed, but I'd let the Pastafarians be a religion if they really wanted to be. And I doubt
the pink poodle.
And I doubt the world would come I doubt the world would come crashing to an end. The pink poodle's a little hard, but I would certainly protect their rights of conscience.
whether I'm going to give them a tax exemption, I might be interested in knowing whether they were, engaging in billions of dollars of illicit trade in vodka, the way that the Orthodox Church in Russia does. I mean, they use their tax exempt status to get out of having to pay any income tax on sort of very lucrative businesses, primarily in what we would think of sin industries, tobacco and alcohol.
Great. Well, we have some time for questions, and one, yes. So if you could just come and up to the microphones, anyone who wants to, and we'll get to as many as we can. Unfortunately, we're as always running a little short on time. But please go ahead.
I'm very intrigued by this notion of broadening out the definition of religion and aligning it with expression, and it seems to me that on the free expression side in the Constitution, that's often what's done anyway, and what you have in these cases is sort of toggling back and forth between free expression and speech and artistic expression, like we've seen in Masterpiece Cake. But what about the Establishment Clause side of the Constitution? There, don't we need to preserve a distinct notion about religion in order to protect society from religion, which is the point of the Establishment Clause?
I'll try to be brief. It isn't easy for me, as you've already detected. The Establishment Clause is primarily used to protect the state from the domination of a dominant religious group. And so fringe groups are not going to really create a big Establishment Clause problem. The biggest challenge is that the most interesting challenges related to your question have come up with claims that secularism is a religion, and by teaching things like the theory of evolution, that you are pushing a secular religion upon people, and this is a violation of the Establishment Clause. The Supreme Court has not found those arguments tempting, and they have not been willing to treat secular viewpoints as a form of religion. But we've seen places where secularism becomes a very hard ideology, and it looks awfully intolerant and awfully dogmatic and even fundamentalist. I'm thinking of Albania during the Soviet era, or the Soviet Union during the Soviet era, or China during the Cultural Revolution era. You can certainly have dogmatic secularisms that look pretty coercive. And so what I really worry about is the coercion. I care a lot about conscience, and it might be religious or it might be non-religious conscience. That's why I don't care so much about the definition of religion, because I want conscience to be broadly protected, whether it's religious or non-religious.
Yeah, I also think, the essential notion behind the Establishment Clause, the government shall make no law respecting an establishment of religion, was really facing in two directions: to protect religious institutions from being constrained by the government, and then to protect the government from being unduly influenced, or giving undue influence to particular religions over others. So I don't think its original conception was simply to protect secular life from religious influences or protect the government from religion, but initially at least to protect religious institutions from interference with and domination by government.
A question for Professor Scharffs. Instead of the Supreme Court or Justice Kennedy deciding Obergefell v. Hodges, wouldn't it have been better to have achieved the same result via an Article 5 constitutional amendment?
Yes. But it could have also been done through the ordinary legislative process that was taking place. If you look at the places where same-sex marriage was enacted legislatively, there were always protections for conscience built in. Massachusetts, no, because that was the court. New York, Vermont, yes, because those were places where the political process worked, and it was quite clear that there were going to be explicit protections for religious conscience.
I don't disagree with that, and in general, I think it's better when the court leaves to the political arena things that are essentially political decisions. But I think that if we had here on the panel somebody from the LGBT community, they would point out that the fundamental problem with that is that political rights that can be granted can also be withdrawn. And a right is on a substantially different footing if it is grounded in a constitutional principle. So I agree with you. Same-sex marriage was adopted legislatively in my home state of New Hampshire, and it was a good process because there was lots of debate and discussion and compromise was reached. But as we're seeing now, when you change from one administration to the other representing different parties, what is enacted politically can be can be overturned. And so I think that's where you'd run into some real resistance from certainly people from the LGBT community.
And only to add to that, there was no appetite in that constitutional amendment was not about to be enacted through the Article 5 process. So that it's a nice question, but it wasn't really on the table. The other issue is that the rights of conscience really didn't apply in the Obergefell issue because it was a question of whether the state was going to recognize for the granting of state privileges, which is not an individual right of conscience question, but implicates somewhat different issues. The state of New York can't claim a free exercise exemption to deny state privileges to some of its citizens. So, which is not to say that the question of whether political or judicial resolution of questions like this are not incredibly important ones to think about normatively, but it raises a whole host of issues, some of which we'll get to talk about in the afternoon session, which I think will be great. Okay, we're all running. So if you can give if we can be as short as the last question, it'd be great.
Great. My question is for Professor Scharffs as well. It's about the Colorado cake case, and my question for you is, where do you draw the line, right? So, and especially if you think of states where it's conceivable that folks will keep turning you away if, say, you putting yourself in other people's shows show up with your boyfriend. Thank you.
Yeah, I'm not sure exactly where to draw the line, but I think there are pragmatic solutions to most of these cases. And so when I defend the rights of conscience of the Colorado cake maker, I realize that it might work against me as well. Because it may be that I go into the bake shop and I say, I'd like a cake with angel Moroni put on it, and the baker says, that's not my thing. And I'm going to say, okay, I'll try another baker, and I'm not going to sue them for religious discrimination. And I'm willing to live in that world. I'm willing to live in that world where I have to suffer some affront, some discrimination, and I don't have to think that baker's right, or I don't have to like them, or I don't have to go back and go again. But you're right, I am kind of assuming I can find another baker somewhere. And so when it comes to things like, medical services, I would want to have conscience protections for doctors and pharmacists, but I'd also want limits on those conscientious protections when there were no reasonable alternatives available and someone really has a constitutional right. So if you have a constitutional right to an abortion and there's no other person available who can do it, then I think that doctor could be coerced. But I think those are mostly academic questions. I think for the most part, what we ought to be trying to do is find ways to create elbow room where we can protect both the rights of the doctor and the rights of the person seeking the abortion. I think in the cake baker case, I don't think it was a case of someone really being humiliated or really not having ready options available. And so that doesn't seem to be the type of harm that would trigger the need to impinge conscience. But I realize there are going to be harms where conscience does have to be coerced. That's for sure. And I think basically the compelling state interest test does a pretty good job of helping us sort through those issues. It's not going to always get the right answer, but it's a balancing test, and we're good at that. We do balancing tests. It's kind of how we figure out the limits of religious freedom in the Employment Division versus Smith World. Religion didn't always win. It usually lost at the Supreme Court, but it lost after the balancing took place and after the religious claim was taken seriously, and then the government's interest usually outweighed it, and then it triumphed. And so religion was never a trump card that could be used to hurt, to really do damage to other people's rights.
And I just want to add one thing on that very quickly, and that is that I think for many people who would support the right of the baker, they feel quite sincerely that that cases like this are not really about the denial of service, not really about access to a wedding cake, but are about an effort to get society, as it were, to go on record as saying your views are illegitimate, to sort of delegitimize in the public sphere and in the sphere of commerce the views and the perspective of those who hew to certain traditional religious beliefs. And I think that that's actually been bad for society. I don't think that that's helpful to moving us beyond these fights, because when people feel that their very sincere beliefs are being attacked as equivalent to really invidious discrimination and hatred and bigotry, that does not, I don't think, move us in a positive direction. And I would venture to say that many of the people who have found themselves on the receiving end of lawsuits about cakes or florists and other such, and particularly wedding vendors, would say that's what they feel has been going on, an effort to say your perspective is not legitimate and must be driven, sort of underground to some degree.
I agree with that. I think the closest analogy are the flag salute cases. In Gobitis in 1940, the court said, you must salute the flag. This is really important to national unity. It's important. Patriotism is really an important value. And it unleashed a horrendous wave of anti-Jehovah Witness violence. Kingdom halls being burned down, homes being vandalized, person castrated, people getting beaten up, sheriffs arresting Jehovah's Witnesses and putting them in prison for inciting violence because the mob was coming to beat them. And 3 years later, the Supreme Court did something it rarely does. It said we were wrong. And in Burnett, they say, we're not going to compel you to salute the flag. And I think if it's the Stars and Stripes or if it's the rainbow flag, we shouldn't be compelled to salute. Now, let me be clear. I don't agree with the Colorado baker. I don't know about this, but I think most Mormons would not have a problem making a cake for the gay couple. I mean, we're sort of we have different views about how moral complicity works. We're used to serving alcohol to people even though we don't drink, and selling cigarettes to people even though we shouldn't smoke, and things like that. So I think that it's not that I would take the same view as the Colorado baker, as I just want to live in a world where we have some elbow room, where we have some constitutional space to live our conscience, not because we agree with everyone else's exercise of conscience, but because we want to live in a world. And not just because it might be our conscience tomorrow, but because we want to live in a world where conscience is valued and protected and given some space, not unlimited, but given some constitutional space.
Well, great. Unfortunately, we're out of time right now, but we're in 10 minutes. If we can come back at 3:15, we'll have a panel in which people can talk about. Of course, the question is, if you have a right but not unlimited, where do the limits rise? And Washington State Washington State courts have been adjudicating, and Washington State litigants have been pushing forward a whole series of cases in which people are trying to understand, if we all agree that conscience counts and we all agree that it has limits, then how much does it count and where the limits are? And we'll go talk about where law is in Washington State in the next hour. Thanks.